hear about Japan's catch-all controls that has been enhanced on the 4th of April. And also in the press, it's never all that there are transit transshipments and illegal transshipments taking to North Korea. And you heard from the morning that Singapore has commercially banned all trade with the DPRK since November of 2017. And yet we continue to see this, and the example from South Korea also demonstrates that. So without further ado, I'm going to invite our first speaker from the European Union, Mr. Philippe Dupuy, Minister Councillor and Head of the Economic Trade Section of the EU Delegation to Singapore, to deliver his presentation. Philippe, please. Thank you.
Well, estimated audience, ladies and gentlemen, good afternoon. I understand that I stay in the way of your afternoon nap or post-lunch nap. I hope I can keep it a bit alive. So first and foremost, I would like to thank, of course, the organizers for the kind invitation and the, this opportunity to give you an update on EU strategic trade controls. It is always a pleasure to engage with stakeholders and trade professionals, trade practitioners. I also would like to take this opportunity to welcome the engagement that we have with the Singapore authorities on these matters. Now, today I would like to cover three subjects. First, the EU economic security strategy as the, let's say, the broader policy background for our economic security policies. Second, the EU export controls as one key policy under this strategy. And third, the current EU sanctions regime in the context of the Russian aggression against Ukraine. Now, for the first point, the economic security strategy, my predecessor, Justina Lasik, has presented to you last year in this forum this strategy. Let me thus remind, as a kind of larger introduction, its context and its main tenets before moving to the update. I believe that this is important to explain where we come from in our recent development and use of trade tools. So when we talk about update, it is also important, to my opinion, to know why we update and what the context of the updates are from the European perspective. Now, the COVID pandemic, Russia's war of aggression against Ukraine, the rise of geopolitical tensions, hostile economic actions, cyber and infrastructure attacks, and disinformation have exposed vulnerabilities in the European economies and exposed the risks inherent in excessive economic dependencies. Deep technological shifts are adding to the complexity of security challenges. Hence, in the current geopolitical context, dominated by increasing technological competition, the boundaries between economy and security are increasingly blurred. The EU needs to maximize the benefits of its economic openness while minimizing the risks from economic dependencies and vulnerabilities. Why is this so important for the EU? On the one hand, openness and external trade have traditionally been the base of our prosperity. On the other hand, the increasing weaponization of the economy that we currently experience and the fact that the EU and its member states have been the target of deliberate economic pressure in recent years made us realize that the risks from economic dependencies can challenge the functioning of our democratic societies and of our economies by limiting our ability to act in the interest of our citizens. At heart, this is also about freedom and sovereignty. And the EU is not alone in having to manage these risks. Countries all over the world have begun addressing challenges to their economic security. As a consequence to these challenges, the European Commission published the European Economic Security Strategy in June 2023, which sets out the broad approach. The aim is that with the strategy, the EU and its member states will be better equipped to commonly identify and assess the risks to its economic security, to use strategically the available tools for dealing with these risks, and to develop new tools where needed. Key guiding lines of the strategy are compatibility with our international obligations, our reliability as an international partner, and proportionality. The key word is de-risking. What are the potential risks this strategy aims to address? Well, I think this is pretty common to all the countries, is the risks to the resilience of supply chain, including energy security in the European case, risks to physical and cybersecurity of critical infrastructure, risks related to technology security and technology leakage, risks of weaponization of economic dependencies or economic coercion. This can also be market manipulation, deliberate supply chain disruptions, for example, on energy, raw materials, or pharmaceutical components, as we have experienced it. The EU Economic Security Strategy and the EU Economic Security Package that implements it work around three dimensions: promote, protect, and partnering. First, promote the competitiveness of the EU by bolstering its single market, innovation, technological and industrial capacities, by making our economy and supply chains more resilient. Second, protect the economic security of the EU through a better use of existing tools, but also through the elaboration of new tools. Key instruments are, for example, foreign investment screening and the anti-coercion instrument. And they are, more specific to the discussion today, the existing dual-use export, or there is the existing dual-use export control regime, on which I will expand in my second point. Besides that, the EU has been developing sectoral tools to reduce dependencies, on which I do not want to expand further here. The third pillar under the strategy is to join with others to strengthen economic security, notably by working with reliable partners to address shared security concerns through diversified and improved trade agreements, strengthening international rules and institutions, and investing in sustainable development. What has changed since last year? Mainly policy-wise. Through competitiveness policies, the economic security is now integrated into macroeconomic governance, structural reform, and fiscal policy issues, rather than only investment and trade policy. The European Commission is working on a new doctrine on economic security to shift from risk identification to risk mitigation and a more coherent use of the existing instruments. The doctrine is meant to link and guide many policies: trade, investment, export control, industrial strategy, supply chain resilience, and give clarity on when to deploy tools. Thus, the strategy evolves into a more structured doctrine with consequences on implementation. And the EU is working on further instruments to address our economic security needs. Building on the white paper, the Commission published on 15 January 2025 a recommendation calling on EU member states to review outbound investments of their companies. The recommendation applies to 3 technology areas of strategic importance, as well as high-risk semiconductor, artificial intelligence, and quantum technologies, and calls on EU member states to assess risks to economic security potentially arising from such transactions. The review will inform a decision on whether further action is needed to address any risks identified. The Commission's ultimate objective is to prevent EU outbound investments from negatively impacting the economic security of the Union by ensuring that key technologies and know-how do not fall in wrong hands. Now to my second point, export controls. The EU export control regime is a particular expression of our economic security policies. Let me again connect with what was briefly presented here last year and talk about the EU white paper on export controls. Maybe we can just go to the first slide, please. Thank you. The white paper analyzes the geopolitical context in relation to the export control system. Indeed, since the entry into force of the EU dual-use regulation in 2021, the global context for export controls has fundamentally changed. First, while important work has taken place at the technical level, the ability of the multilateral export control regimes to deliver new decisions on items subject to controls and to keep pace with technological developments, has been hampered by certain members, notably Russia, creating gaps in the adoption of new export controls at multilateral level. Second, Russia's invasion of Ukraine has been met with unprecedented and rapid deployment of export restrictions on dual-use and sensitive items, critical for curbing Russia's capacity to wage war. This has highlighted the need for the EU to have a system of export controls that can deliver fast and in a uniform manner. Finally, notably as a consequence of the more restricted ability of the multinational regimes to deliver, there has been a multiplication of new national controls on emerging and advanced sensitive technologies by some countries, including EU member states, outside the multilateral framework, creating a patchwork of control measures, notably within the European Union. Excuse me. These changes, thus, bring new risks. The patchwork of national control legislation in the EU means lack of clarity for exporters and other member states, forum shopping, and ineffective exchange controls. The lack of common approach to EU security and trade policy exposed the need to allow for swift EU-wide reaction when needed to security risks as regards emerging technologies which have not yet been controlled at multilateral level. There is need to increase the ability of the EU to act jointly and geopolitically in response to third countries' calls for new export controls on emerging technologies. There is need to allow a common EU risk assessment of controls that have an impact on the EU's trade relations and on supply chains across the European Union. Can we just move to the next slide, please? Thank you. Now, as a consequence of this analysis and the identified risks, the EU White Paper on export controls outlines how to make EU export controls more effective in the current geopolitical environment. The White Paper proposes both short and medium-term actions to create uniform and effective controls across the European Union. One of the proposals is the possibility to add new items to the common EU dual-use list that haven't been formally adopted by multilateral regimes. This would close gaps created by delays or blockages at the multilateral level, ensuring that the European Union maintains control over the export of sensitive items. The White Paper also proposes better internal coordination in the European Union and makes a recommendation to increase coordination on national measures. This would foster a common EU position on export controls and in particular further improve the coordination of national measures. Now, what has then since the last forum last year changed? On 8 November 2024, so just after this forum, there was the yearly update of the EU dual-use export control list, the Annex 1 of the EU dual-use regulation. In April 2025, following on the White Paper, the Commission issued a recommendation to better coordinate EU member states' national control lists. It is a non-binding recommendation for member states to coordinate, to base lists on objective technical parameters, and to share draft lists for feedback before formal adoption. The aim is to reduce national divergencies and weak links. Throughout 2025, several member states have used national powers under the dual-use regulation, the Article 9 of the dual-use regulation, to impose extra authorization requirements for certain tech, quantum, advanced electronics, semiconductors, pending EU coordination. Next slide, please. Finally, recently, on 8 September 2025, the Commission adopted a delegated regulation updating the EU dual-use list in Annex 1 to the dual-use export control regulation. The update brings the list in line with the decisions taken in the multilateral export control regimes, the Wassenaar Agreement, the Missile Technology Control Regime, Australia Group, and the Nuclear Supplier Group in 2024. This update provides for the addition of new dual-use goods to the list for the modification of control parameters and changes in definitions, for example, satellites replaced by spacecraft. If you go on the QR code, you will get a link to the detailed list. So in summary, what is new there are controls related to quantum technology, semiconductor manufacturing and testing equipment and materials, advanced computing, integrated circuits and electronic assemblies such as field programmable logic devices and systems, coatings for high temperature applications, additive manufacturing machines and related materials, peptide synthesizers, and modification of certain control parameters and update of certain technical definitions and descriptions. Now, this list is not yet in force. There is a non-objection period of 2 months of the European Council, so that's the European institution of the EU member states and the European Parliament. If there is no objection between these 2 months, so upon expiry of this period, the Commission delegated regulation will be published in the official journal of the European Union in November 2025. So imminently. A comprehensive change note summary, update 2025, will provide a detailed overview of all changes to the EU dual control list across 10 categories. Thus, in conclusion, with the changes, there is a wider scope of control items, updates that explicitly capture some emerging technology categories. There's a greater EU-level coordination and nudges for national alignment, lowering the chance for inconsistent national rules. There's movement towards autonomous EU measures where multilateral regimes are blocked or too slow. More active monitoring and possible enforcement attention is also coming up. So that also means, let's say, as consequences for exporters, that the screening needs to be more thorough, and it needs to be checked that whether items which previously were not controlled may now need licenses. And the license vetting and the due diligence could be tightened. Now to my third and last point, the EU sanctions against Russia. If we look at the developments since last year, the 15th to 18th packages of sanctions were adopted between November 2024 and July 2025. Together, they included, among others, expanded export bans on advanced technology items and dual-use goods to Russia, and an increase of the list of sanctioned vessels of the shadow fleet. The packages also introduced an import ban on refined oil products from Russian crude and financial measures, notably broadening the transaction ban for third country financial operators. There are further trade restrictions, notably on advanced technologies. The packages also included anti-circumvention measures and notably added new entities in third countries to the list of entities that circumvented EU sanctions. Lastly, on 23rd October 2025, so basically 10 days ago, the Commission adopted its 19th package of sanctions against Russia. Main elements: a ban on Russian LNG, elimination of exemptions for major Russian companies on oil and gas imports, further export restrictions on dual-use advanced tech items, further sanctions on shadow fleet vessels, increasing targeting of crypto, fintech, enabling Russia's war economy. And there are also targeted sanctions on persons involved. As a consequence, companies trading with or in Russia face increasing risk of export bans, dual-use item restrictions, asset freezes, and enhanced due diligence, not only in the EU, but also not only EU entities, but also third country entities. Financial institutions and fintech crypto must monitor closely, since the 19th package explicitly included crypto infrastructure enabling the Russian economy. Service providers, be it logistics, transport, insurance, shipping, especially around the shadow fleet, will face stricter vetting and prohibition on surfacing or insuring covered vessels. I leave it at that, and I thank you very much for your attention. Thank you.
Before I invite the next speaker, I'm also again gently reminding those who are joining us online, you need to click on live stream. If not, you're not going to hear or see very much. So you need to click live stream and get into the live stream virtual portal. With that said, let me now invite Mr. Suimori-san from Japan to present you updates from Japan. Mr. Suimori-san, please.
Hello again. The presentation from our EU colleague was very insightful. The term level playing field is very important. If you feel, not you, if I feel frustrated with some regulations or if I feel nervous, the regulation, I will insist that the level playing field should be achieved. But if I am making use of unfair situation, I don't say anything. So level playing field is very good term. Of course, I respect the level playing field, but sometimes I think achieving level playing field among the market, among countries, is very difficult to achieve. But my mission is to achieve level playing field and to consult or to keep consulting with industries. And then I really respect the level playing field. That's true. And then go to the slide. This is a Japan Security Trade Management System that is implemented based on the Foreign Exchange Foreign Trade Act, commonly known as FEFTA. So in our country's legal system, security trade management is regulated across 3 tiers. The law, known as FEFTA, is established by National Diet, and at the next tier down, 2 cabinet orders are defined. That is the Export Trade Control Order, which corresponds to the export of goods, and the Foreign Exchange Order, which corresponds to the transfer. Thank you. Transfer of technology. Furthermore, at the lower tier, there are various METIS ordinances. Okay. Oh, sorry. This one. The item subject to security trade management are specified by cabinet orders, such as Export Trade Control Order. Further details regarding the specifications of these items are regulated by METI ordinances. Japan's controlled items are fundamentally in accordance with agreements established by international export control regimes. METI revises and updates the relevant cabinet and ministerial ordinances. The 2 pillars are security trade management. Those are list-based regulations and catch-all regulation. Update of list controls. It's not decided yet, but mid of this November, update of list control will be released. And then since, go to the next slide, update of catch-all control. Well, since Russia's invasion of Ukraine, it has been revealed that Japanese-made items, such as machine tools, electronic components, or uh, semiconductors, those have been militarily utilized in conventional weapons. In response, METI has decided to review the catch-all regulations related to conventional weapons. A new system will require exporters to apply for permission if the items have a high risk of being used in the development of conventional weapons. By clarifying the license conditions, like end user and end user conditions, high-risk transactions will be appropriately managed while considering the burden of exporters. In addition to that, METI streamlines the license procedures for exporters which supplies the regular armed force of like-minded countries, as long as they comply with strict compliance program. In the conflicts in the Middle East, there are instances where components from Japanese companies are being utilized in unintended ways. So some components made in Japan are utilized for conventional weapons. So we have established conditions under which, even for non-listed items, a permit application for the export control authorities is required. We particularly chose specific items like machine tools or semiconductors because such items are frequently used for military purposes, even though they are unlisted items. This scheme has been effective since this October. The measures for Group A are as follows. In the context of the conflict in Ukraine, we have confirmed instances where Japanese-made components have been used in unintended ways through countries that belong to Group A. Therefore, METI identifies transactions of concern in advance. Even if the transactions are directed toward Group A, it has been established that an export permit may be required through a notification from METI. Sometimes we do that. And then, next slide. I'd like to talk about a little bit examples. These days, a lot of dual-use components are used for military drones or even ballistic missiles. Of course, these items are restricted under MTCR and Wassenaar arrangement. However, specifications under two regimes are not enough to control all of the transactions. Some of the components are difficult to control because these components are too small to detect. Or if the producer sells the components to the market, we cannot follow the ultimate end users. Sometimes we got the information that made in Japan components are used for military activities unintentionally. Unfortunately, it was sometimes true, and it was not true sometimes. Based on that situation, actually some foreign companies have introduced products with false made in Japan logo on that. So authentic and famous Japanese companies should protect such bad activities. Countermeasures against counterfeit. That is very important, and such a kind of activities as follows. One is countermeasures against counter profit product is here. Sorry. So assign serial numbers to track primary suppliers. Stick hologram seals inside the product. Implement undisclosed verification methods. That is very confidential measures that was done by private companies. In addition to countermeasures against counterfeit, of course, industries, the companies should review the transactions. So the suspicious activity, we should protect the suspicious activities. One is sudden surge in orders or orders received from countries with no prior business relationship, or special instructions requesting anonymizing the shipper sender information. We introduced red flag information in public. We know that the United States also published before such kind of red flag activities. We can learn from those publishments. And then it is crucial to verify the circumstances to understand the reason. So the transaction review is of importance. Case study 2 is that I'd like to introduce 2 examples of this violation cases in Japan. One is lack of international control system. So there is a problem with the system that allows exporters to be conducted based on the person in charge discretion without internal approval. It is very essential to establish an export control system to identify and avoid potential risks in advance. Of course, there are a lot of ICPs. We admitted by METI. METI admitted each company's ICP, but enforcement is important. We will visit. We have visited a lot of companies whether the ICP can be working effectively. That is important because we will give the general license based on ICPs. So inspection process is very important, I think. So another example is that sorry, believe another company's information unconditionally. The non-classification certificate from manufacturer stated that the goods were not subject to export controls. But actually, the classification was wrong. Exporter must examine whether the goods are under the law or not. So, since the exporter classification must be conducted under the responsibility of the exporter, it is necessary to re-verify all classification related to information obtained from other companies. Well, sometimes it happens, and then, of course, manufacturers knows well the specifications, but sometimes, for example, exporter would like to export 5-axis machine tools. That is under the law. But they add 4-axis permission or classification or document. They could have known the situation, but based on their ICPE procedures, their system cannot work properly. We would like to, the METI side, regulation authority, should detect and suggest how to improve that. Another topic is overview of Japan's export-import measures against Russia and Belarus. Just a quick quickly inform the situation. I don't explain detail of sanctions, but the Japanese government imposes export and import measures against Russia and Belarus. And then, in addition, with like-minded countries, we have added sanctions on Russia. Okay. Oh, and the METI decided to extend strict export and import ban against North Korea in December. And this is a current update on basic Japan's export control measures. I really appreciate your comments and having dialogue. Thank you.
Thank you, Mr. Suimori-san. So I think just from Mr. Philippe's presentation and so far with Mr. Suimori's presentation, you already can see the interagency and from investment screenings, outbound, and you've also seen Japan giving you examples of innovative mechanisms that you can deploy in order to create that competitive advantage to get ahead of the curve. Serial numbers, holograms, these are voluntary measures that companies have apparently adopted. So it seems like trust but verify is the mantra to go by. Now we invite our final speaker, who is the chief of the International Cooperation Team Policy Support Department from Korean Security Agency of Trade and Industry. It gives me a delight to invite Ms. So-Young Kim to present her presentation.
Good afternoon, everyone. I'm So-Young Kim, Chief of International Cooperation Team at COSTI. First of all, I would like to express my sincere gratitude to Singapore Customs and organizers for inviting me to give a speech today. Through this opportunity, I hope we can further strengthen the relationship and the cooperation between Singapore and Korea in the area of the trade security, while learning from each other and sharing our respective perspectives and systems. Today, at the Joint Industry Outreach, I brief you on recent update to the Republic of Korea's strategic trade controls, the current enforcement landscapes, and practical implication for Singapore industry. Let me start with the frameworks. With the strategic trade management comparison between Korea and Singapore, I would like to know what kinds of differences and similarities exist when it comes to implementing the system in each country. Korea operates a three-tier structure: Foreign Trade Act, Enforcement Decree, Strategic Item Notice, that incorporates multilateral export control regime decisions into domestic laws. Singapore's system is built on Strategic Goods Control Act, SGCA, Strategic Goods Control Regulation, SGCR, and Strategic Goods Control Orders, SGCO. As you are all familiar with it, administered primarily by Singapore Customs. If you run a business or operate a manufacturing facility in Korea and need to review the criteria and standards for classifying strategic items to be exported from Republic of Korea, and for certain exemption cases, you may refer to the ROK Export Control Notice. For classification before licensing, just a kind of the permit, COSTI as an independent agency has a classification mandate granted by the Ministry of Trade, Industry and Resources, which was called as a MOTOR, under the Foreign Trade Act. COSTI mainly conduct expert classification reviews submitted by exporter to determine whether the items to be exported fall under strategic items before they apply for an export license. Singapore relies on Singapore Customs. Both the jurisdiction apply regimes-based control list. Korea issues individual and bulk user item-based license. In contrast, similarly, Singapore issues individual, bulk, and ITT permits. The differences between Korea and Singapore lies not only in the validity period of the license, but also in the requirement for a bulk license, particularly Korea's classification by destination groups according to A, B1, and B2. I also found that Singapore operates a separate ITT, intangible transfer technology permit systems, compared to Korea includes strategic technology license for ITT. Both the jurisdiction operate ICP corporate compliance programs and catch-all controls. We operate an ICP system classified into three types: single A, double A, and triple A, which provide different privilege for each grade. Electronic filing is via Yes Trade system in Korea and TradeNet in Singapore. In our Yes Trade system, exporter can use the self-classification function after completing the online training. Keeping the comparison and explanation in your mind, I will now present Korea's regulatory update, including recent changes and the current status. Firstly, the designation basis has been expanded. Beyond items explicitly listed by multilateral regimes, Korea can now designate items domestically when a measure is adopted or supported by a substantial number of the regime members. This enhances flexibility in reflecting real-world international coordination, which is crucial for addressing unexpected risk and inevitable circumstances in strategic control management. Secondly, COSTE's mandate has burden. In addition to classification, training, and information service, COSTE now supports a policy development in trade security, industry impact assessment, expanded consulting and outreach, and support to Council for control of exportation and importation of strategic items. For companies, this provides greater predictability in classification and strengthens the feedback channel between industry and policymakers. Third, enforcement tools and penalties have been upscaled across the board. Notable changes include stronger penalties for failure to provide classification evidence or exemption documentation, stronger penalties for non-completion of mandatory training and failure to register self-classification results, expanded sampling reviews of exporters' self-classifications, orders to halt illegal transshipment or transit, new strengthened penalties for breach of license conditions. The key takeaways are summarized on this slide. The update focuses on three main areas: a wider scope for the designation of a controlled list, expanded function of a Korean Security Agency of Trade Industry, which additional mandate, enhanced export enforcement. Companies should prioritize evidence-based classification, pay close attention to Korea's jurisdiction when engaging in transit or transshipment activities within Korea, where the government is conducting joint investigation, and ensure diligent training and record keeping. I don't think I need to elaborate on COSTE history and main function again, as I have already explained them sufficiently in my previous presentation. However, one thing I would like to highlight about our agency is that we have around 84 staff members, and most of our staff are composed of technical experts in various categories such as chemical, machinery, electronics, and materials. We participate in every export control regimes conference and are actively involved in the overall process of revising and proposing new control criteria. As you all know about that, strategic items technology cover goods, software, and technology that could be used for WMD or conventional weapons, spanning 1,800 categories. Crucially, in Korea, providing technology to a foreign national within Korea can be deemed an export. That means the remote access, download, training, and technology support may fall under controls. Transfer to foreign persons, whether conducted within or outside the Republic of Korea, are deemed export. National core technology, where overseas leakage would critically harm national security or the economic carry obligation for holders. Protective measures to prevent leakage of national core technology, prior approval, notification for export or overseas M&A, protection of national funded R&D outcomes, and reporting obligation in the event of leakage and infringement of industry technologies. Together with export control, the NCT, National Core Technology Regime, forms a multi-layer safeguard. Among the multi-layer safeguards, we have introduced the foreign investment security review for both inbound and outbound investment in Korea. Korea's review process, National Security Subcommittee, Foreign Investment Committee, material final decision, focusing on defense, dual use, NCT, and sensitive government contracts. The 2025 legislative direction expands scope to indirect control. We recently reinforced our system is extending review periods and adding new grounds for screening indirect investment through subsidiaries or private equity funds. The lesson here is that STM is not only about exports, but also about protecting critical industry and technology from unwanted control. Contemplates criminal penalties for deceptive structures and burden of coverage to investment presenting advanced strategic trade technology liquidity risk, regulate cases where foreign entities indirectly acquire management control of domestic companies in addition to direct acquisition if it poses a national security threat. Early deal struggling should factor in these securities risks, including for Singapore investors in Korea. Here is the presentation for export control enforcement in Korea. Illegal activities under export control laws includes exporting control items without required license, brokering transshipment of control items without required license, obtaining license by fraud or other improper means, non-compliance with export license conditions. Let's start to explore the export control enforcement in Korea from this time on. Again, Korea targets illegal exports, willful violation, and fraudulent license, including brokering and transshipment. Penalties include criminal penalty, up to 7 years imprisonment, fines up to 5 times the amount of the illegal transaction, and administrative measures for trade restriction on control item for up to 3 years, and 8 hours mandatory training. Following the Russia-Ukraine war, international cooperation has intensified. Korea operates a cross-government enforcement working group. Agencies coordinate closely MOTOR, Customs, National Intelligence Service, MOFA, Finance, Data, Defense, MOEF, Economy, and COSTI through regular joint investigation, notifying criminal cases information, requesting cooperation to investigation actions. This institutionalized information sharing, joint investigation, especially targeting unlicensed export and third countries circumvention. For companies, the practical message is clear. Build traceability and documentary evidence across the entire transaction chain. Here is a simplified outline of the joint investigation process. MOTOR, Customs, and Intelligence Agency first identify the suspicious exports and share information. Customs review export clearance records, while COSTI classify whether the items are strategic. Authority then assess for willful violation or criminal intent, and after document request and compulsory investigation, penalties are imposed, either administrative or criminal. The case is handled by a working group on export control enforcement since February 2023. Here are the publicly available activity record from 2024 to 2025. As of February 28, 2025, the working group has held a total of 20 member meetings and have investigated unlicensed export, including cases related to Russia-related circumvention. In addition, it has been cooperating with the US, the EU, and other partners under the Disruptive Technology Protection Network, which was called the DTPN. Now we can explore the best practice we've gained through enforcement efforts, joint investigation from the Interagency Working Group. In June 2024, authorities seized AI semiconductors worth $7.5 million at the border, which were being exported without a license. There was a risk of diversion through South Asia to China. This case demonstrated the importance of STM in closing security gaps. It also showed the value of enforcement tools such as joint inspection, voluntary self-disclosures, and risk pattern analysis. Let me share one more cases for domestic inter-agency cooperation involving joint inspection and data sharing among Custom Motor and COSTI. This case reported on July 27, 2025, illustrated how 5 departments form a one team approach to block 110,000 items at the border stage. Over the past year, the collaborative information team dispatched employees to work jointly at the Customs Border Risk Management Center. Major items seized included Chinese batteries that falsely inflated their capacity, and high-performance AI semiconductors that were being exported as treasury goods without authorization license. With a government mandate for training, COSTI conducted regional export control seminars. These seminar topics cover areas such as the prevention of unauthorized exports, case study on strategy items classification, and overviews of government support programs. This year, we held 9 outreach events across different regions in Korea, attracting a total of about 550 participants. These in-person programs aim to engage exporters in remote areas on a monthly basis. In addition, we offer several types of the virtual and in-person training courses that are open to the public every month. With the mandate for international cooperation support granted to COSTI under the Foreign Trade Act, we have been actively participating in international outreach programs, not only with our target partner countries, but also in response to cooperation risk from our international counterparts around the world. We have contributed to building export control capacity in countries such as Vietnam and Indonesia by introducing Korea's export control system operational practices, including classification process and corporate compliance programs management. As Singapore Customs plays a pivotal roles in Singapore's STM system, COSTI has also expanded its expertise and mandate in this area. Based on the comparison I shared earlier between our two nations' STM system, I believe we can continue to develop each country's unique STM framework through close cooperation. Thank you for your attention.
Thank you, Ms. So-Young, for your presentation. I think we've had a good kaleidoscope presented to us in terms of some of the developments, both near and not so near. I wanted to now use this opportunity to deep dive into some of the many questions all of you have. In fact, it goes into a stream. Can I give all of you the opportunity to vote on your questions as we maybe start off with some on stage? We never want to feel that you're unheard. So you'll always have an opportunity to interact with the speakers after the event during your final tea break. But I'm just going to give you about 10-15 seconds to get onto Cvent, for you to see whether there are some questions there that you want answered. If your question currently has 0 votes, then the chances of it being asked up here is not very probable, but we will try, especially for the ones which I've spotted that I think would be of broader interest to many. I think the presentations that we have heard from you straddle a lot of what we have been covering as recurrent themes, and perhaps this is something that I would start with, and this is one of the questions that was posed. In terms of voluntary self-disclosure, I understand that different countries have different channels. It's directed to Japan and Korea first. Can you tell the audience here a little bit about your voluntary self-disclosure regimes so that businesses here can take advantage of those if they need to? Whoever wishes to go first. Ms. Soyoung, do you also have a microphone with you? Do you have one? Just in case. If you don't, there's a spare here. Okay, great. Mr. Sumari, please, go ahead.
Well, voluntary self-disclosure system is very important because, of course, by law we introduce the criminal punishment. In addition to that, we introduce administrative punishment and guidance. If exporters voluntarily confess what they did and what they did was wrong, that is some elements to consider our guidance. And then, of course, not only just voluntary action, we have to consider the elements of consideration. For example, end user were wrong, or classification was wrong, or did they know the situation or not? Is that intentional activities or not? So it's just one element, but it's an important element to consider. And then in terms of goods, we do need to stop the goods, even though that transaction might be delivered to wrong end user. But after that, we can effectively stop those transactions. That is also important. In this context, we would like to encourage the exporters voluntary self-disclosure.
No, I think what they're also trying to ask is, what is the channel? Is it an email that is sent to METI, or is there a portal that they ought to access?
Basically, based on email. Sometimes telephone is acceptable, but
You'll take Mr. Sumori's mobile number before you leave.
But rather than telephone, it might be better to leave some contents. Email might be good, and not only just voluntary action. Another such as condemns from rivalry companies. Also, such kind of information.
Very nice. I think it's very helpful to know that when you're going to make the voluntary self-disclosure, you have heard from Mr. Sumori-san that it's useful to have context. So in order for you to do that, you want to do some basic investigations that many of you would do, and to be able to staff it up with enough information so that the regulator receiving it is able to cooperate with you and work with you. I think that's a very helpful reminder. Ms. Soyoung, how about in Korea? Is there a mechanism that you can speak to that they can pick up on?
As I heard Suemori's explanation about Japan's status, I thought that we also have a quite similar mechanism to Japan's systems. So just when it comes to self-disclosure after exporting, just they can reduce when the exporter notice about the exported items or the end user are not correct or misused, they just through self-disclosure, they can reduce this sentence or penalties, especially for criminal or administrative penalties. So, as you know that in the world there's a kind of very sophisticated, complicated end use and the users. So when they try to deceive the counterpart, they just unintentionally deceived by them. So that's why you need to be very conscious about that. And that the question for the channel to report the disclosure, to be honest with you, I'm in the part of the classification authority, so I'm not a licensing part.
Yes.
So likewise, I hear Suemori explanation, the channel would be via email or just contacting by person via phone call.
Good. That's very helpful to know, helpful to hear, 2 scores, that there is a recognition from a mitigating perspective by voluntarily self-disclosing in Korea, and that you can avail yourself to emails and phone calls, which makes it very approachable. So thank you for those. The next question I wanted to ask would be to Philippe. Let me contextualize this question so that it's fair. It has a lot of votes, so I feel that if I don't, you all may scold me. What lessons can ASEAN learn from the EU? And I paused. ASEAN and the EU are very different in creatures because the EU is a supranational organization that has the ability to lawmake versus ASEAN that doesn't take it upon itself. At least that's based on my honest understanding of the regimes. So the questions, what lessons can ASEAN learn from the EU when it comes to coordination of export policies, where it appears countries within EU seem to have policies at odds with policies the EU is looking to implement. So I suppose the question, Philippe, is for policymakers here, how is it that, what has been your observations in creating coherence, given that it is increasingly challenging?
Yeah, okay. First thing, I think I cannot say any lessons. I think ASEAN and ASEAN member states, by seeing what we do in Europe, then can, of course, also see what have been our mistakes, the lessons we had to learn, and then it's of course the evaluation of ASEAN to see what if there's anything to draw out of that. I think you already made the point. The EU and ASEAN are very different in their institutional structure. Yeah. So the EU institutions, the European Commission, have powers which have been, let's say, referred by EU member states to the supranational level, and that allows us to issue legislation, to issue EU regulations like the dual use regulation, or directives, which are guidelines that member states have to transform into national laws. So it's very difficult to compare because, of course, at ASEAN level there is no structure. But I think what we have learned is how important coordination is.
Sure.
Yeah. Now we can put this coordination into rules. We have, for the moment, worked with recommendations essentially when it comes to dual-use items. And this is, I think, a challenge, or this is a result of a challenge, because we have realized that, if we have a patchwork, even though we align ourselves to the multilateral instruments, we create loopholes.
Great.
That's I think, the key lesson we have learned. Now, of course, our alignment is always with the multilateral instruments, but the problem is things are moving so fast nowadays, sure, and technology is moving so fast that sometimes the multilateral instruments are too slow. But of course, when we do these measures, we look at what is basically ripe at the multilateral to be decided. So there is, of course, a certain line into it. Thank you.
I think that's helpful to know. And for those of you who in the audience are interested, ASEAN has a blueprint document where there has been reference to the need for trade governance. If you want to chase that up, you can find it. If you're interested to know it, you can find me after, and I'll give you the link to the blueprint document from ASEAN. Let me now have the privilege of asking all three panelists the most popular question by vote. Thank you, Sami, for your question. You have gathered the most number of votes. The question is this: many companies rely on third-party screening tools and automated classification system. How do authorities view the role of these tools as used in ensuring compliance with evolving regulations? So the question is, companies are using these tools. How do you, in your regulatory hat, view this? I can at least know of one European Union jurisdiction where the judiciary has come out to say that they are in favor of the organization using automated screening. In that case, ironically, it was the regulatory agency that tried to argue that things should have been done manually, but the court took the view that you ought to be using technology to harness your ability to be more compliant. So there's actually a judicial decision to that effect. But to the panelists, what are your thoughts? Whoever wishes to go first. Are you comforted that people are using technology, and if they're using technology and they made the mistake, are you going to say you are okay? Or are you going to say, well, you've still made the mistake, it was not the best technology, you ought to have been using something else? How are you embracing the use of so many service providers out there who are trying to sell something?
Well, Japanese government would like to support making use of third parties screening system. Of course, there are a lot of participants from here now.
Very nice.
And then the problem is that exporters ask us that is that requirement or not. And of course, we do not say it's requirement. But so if I say so, some companies will say that if it is not a requirement, we do not need to do that kind of research because it's not a legal requirement. And then that might be related to the reason to know. If they know the fact, they have to dig more. They have to research more. That is cost burden for them. So knowing details might cost too much. But so if we ask them to do more, that is that they will complain a lot. So I have a headache. I'd like to make exporters know more by themselves, but sometimes they do not want to do more.
Sounds like the perennial problem of keeping the head under the sand. And if you're scared that if you find out, then you will be imputed with knowledge. But at the same time, if you don't find out, that also presents consequences. So it's the devil in the deep blue sea. How about the others? How do you all feel about the adoption of these technology automation tools?
As of today, Korea's government also don't have any legal framework to impose to use the third countries screening tool. But actually, in reality, there's a complicated entities related to contracts and transaction. So that's why at the beginning of their contract or transaction, they need to know the entity risk assessment based on that kind of screening tool. And then moreover, the government don't have any access to multiple databases based, especially for a company-related information. So that's why it was also the good way to utilize the kind of third countries screening tool before transaction or contract. And that, but we need to keen about the result. It was because we don't need to. You don't need to solely rely on the result from third countries screening tool. Just need to build up your capability to screen by yourself based on the result getting from the screening tool. That was my suggestion.
Okay, that makes sense. You're building up your own capability. Philip, what's your take?
Contrary to my two panel colleagues, I'm not a direct practitioner of of export controls, but of course I know how we normally operate in such situations. I think the first thing is, using a kind of automation or service provider doesn't exempt you from your obligations.
Absolutely.
That's the key thing. I mean, you're not out of the woods because you have trusted a service third party to do the screening on your behalf. I think that's a key principle, which entails, and it's the same as you mentioned. You have to make your due diligence of who you hire and pay for that purpose. And the other thing is, I don't know now in this particular case, but sometimes you can also make reference to standards and standards organizations. So systems can be certified for purposes.
Absolutely.
Now I don't know whether this is in this particular case of screening this is the case, but we know it in other cases where actually systems have been licensed and certified, and therefore the user can trust that the system is reliable, but again, it doesn't exempt the operator from his responsibility. Yep.
I think that's fair. Hearing from the panelists, if you're not doing yourself a favor. They are not going to tell you to use it because you will know best. It's about creating the productivity gains and optimization of your processes, and you're having to manage it. And ultimately, the question that actually is not asked is, what are your competitors doing? If your competitors are using automated screening tools and you are about the same size and you're not, then it'll be interesting, right, to know that how are you keeping up? Are you keeping your head under the sand, or are you just being safe? Are you trying to save money? There's at least one regulatory agency out there that has already indicated that if they're using artificial intelligence for your business gains, you should be using artificial intelligence for your compliance screening too. So there's actually guidelines on this that speak to potentially your approach to technology automation. So I hope that helps. Please add on, Mr. Sumori-san.
A few more comments with respect to this field. Some Japanese companies asked us to do favorable conditions if they research more. My response is that your request is meaningful, but I have to consider the small and medium-sized companies, or for example, cutting-edge technology companies.
Yes.
Coming from a university. They don't have knowledge about export control, but it's important how to balance those areas.
Nice point.
Of course, researching more, making use of third-party screening system, that is important. I'd like to give some preferential fast-track procedures of licensing, but that is very conflict of interest here. Thank you.
I think to echo what Philip says, and he's going to add on, many judges have said this in courts before, that ultimately, even though you were given legal advice, and if your lawyers are wrong, it doesn't exonerate the company. So if you use that same extension, and even if your lawyer gets it wrong, and you are not exonerated. If the technology gets it wrong, you're not exonerated. But ultimately, ask yourself this, it does provide you auditability. It does give you something to be able to say that you made your decision on something, so that's something there to keep your eye on. Philip?
Just wanted to add that I think for us, these situations, I mean, you know, strategic trade concerns are a management concern. It's not something you delegate within the company simply. Management needs to be aware what is happening and has a responsibility. I think that's something we would also look at very much. It's not something you can simply give and forget. You have at highest level to have an eye and know what is happening in your you know your export streams. Yep.
Great. Before we move on to some more questions, for any of you who want your question fast track, PPS style, priority boarding, you can raise your hand and we can allow you to cut through the questions immediately. So now let's carry on with the questions here. There has been a question, it's being asked, I believe, in earnestness. For many of us in Southeast Asia, you know, including Singapore, has got prohibitions as against Russia too. How effective has it been from your perspectives, the imposition of sanctions on Russia? The question specifically asked is, how effective has the use of sanctions been? I know that in many fora, the question of efficiency has been answered in different paradigms. But for all of you, do you have a perspective? And he goes on to add, Kala has asked that, going on to ask, is causing real pain to Russia or is it really causing real pain to the companies? So what's your perspectives?
Okay, I take off on. I mean, of course, you know, we wouldn't take these sanctions if we don't think they were effective. But we also see. I talked about the 19th sanction package. So you know, we have been building this up, and where it is not effective is when there is the possibility of circumventions. I think that's the key thing.
Sure.
The rest is. You know, you build this up. You, of course, while we did our sanction packages, we needed to look at our companies as well and our interests. So this has become success in building up stones. I think the key issue about this is a circumvention. Now, does it harm the Russia or the companies? A company which continues to deal with Russia on sensitive goods, well, they will be harmed. Yeah. I mean, that's because then there has been a circumvention. And it's clear that sanctions always harm your own economy. I mean, Europe has been particularly affected by that. We've seen this, you know, on the energy side in particular. Yeah. Because we were dependent very much also on Russian energy. So that's clear. But, you know, that's a consequence that we had to take from that situation. And the lesson for us is that and that's part also of the economic security strategy, is we have to diversify and de-risk our sources. Thanks.
I suppose that's quite fair, I think. I'm not sure whether Kim and Sumari, you have any observations to add. Do you? If either of you wish to, we can. If not, we have a long train of questions. We're okay? Either of you are fine. All right. Anybody wanting to have their questions fast-tracked? We're looking around. Okay, let's carry on. I think this is an interesting question. Even though it's not voted as high as others, it speaks to something that I believe the resellers, the manufacturers, the distributors here may inevitably face. It's the question of how is it that you deal with counterfeiting, and how has it been, for example, Metti's experience in managing exporters who export counterfeit products. So what has been Metti's experience in managing that? We've seen an increase in smuggling activities, and for businesses that inevitably find that these items were counterfeited, would you have any tips to the people in the audience as to how is it that they can manage these risks? And I also preface by saying that you have mentioned earlier that the use of serial numbers and holograms, this help you create an authenticity for you in the supply chain. If you wish to add, please do.
Well, as I said in the previous presentation, those goods are very small and it's hard to detect. And then the goods are sold to the market, so we cannot find the end user. So the information source is the Ukrainian authorities. They said that the Russian drone is comprised of Japanese small products, or country A or country B or country C. And then the logo shows as Japanese company's name. Or sometimes media would report that some of countries' products can be utilized for military activities of Russian invasion. Or NGO, non-governmental organization, also report through web that they will. And then this is not just breach of export control, but it is related to reputational risk. If they reported that the Japanese companies' products are utilized, so they have to protect themselves. In this context, they would like to introduce such counterfeit measures before they would media or other entities would report that. That is the current situation. And before that, I think rather than manufacturing products, consumer products, like, I don't know, Pokemon cards or some other consumer-related products are very popular for addressing counterfeit products. But currently, the manufacturing products are very important to protect themselves.
So it sounds like if your item itself is susceptible to be misused, then to avoid the problems associated with counterfeiting, you are trying to get ahead of the curve. So that's, I think, a great suggestion to keep in mind. There are two questions for Ms. Soyang. I'm combining them. The first question is from Cindy from Malaysia. I know that you are logging in from a distance. Hello. Under the Korea's Foreign Trade Act, how does Korea monitor and enforce the compliance of your technical expert involved in training and discussions conducted outside of Korea? So it sounds to me that actually we can pose the question this way. How is it that Korea is managing either technology leaks or intangible technology transfers? And that will be a question that perhaps we can have all the panelists chime in on. How are you, I suppose, by way of best practices or observations, giving ideas to our friends here into managing ITT, intangible technology transfer breaches, potentially? And relatedly for Ms. Soyang, maybe the first question to start there is, does Korea use the same definition of deemed exports as that which is used by the US? So maybe we let Ms. Soyang answer that deemed export definition question first, and then we move through the panel on how is it that we can manage ITT-related leakages or threats. Is that okay? Please.
The definition about the deemed export, as I described in my presentation, the deemed export is kind of the technology transfer. Let me give you an example. When the doctor or researchers give a speech to the public using the information open to the public, there was not the limited to the expert control, but When it comes to when it comes to the technology, need to be when it comes to the technology considered by national core technology or dual use technology, or it was not open to the public, they should be protected by the expert control. So there's a transfer technology via phone or in person or just to the public. They also like a deemed expert. I think this kind of the definition is similar to what you are handling in your country. And then back to your first question about the intangible technology transfer. As my comparison between Singapore and Korea, Singapore also has a ITT permit. So during our lunchtime, I asked Lim Soping about the ITT permit systems. So what I understand from our conversation between us, I thought that the ITT permit is similar to us, and then as you know that the strategic items and software is included the technology. So that's why overall general controls is included in our export control system as well. So that was my point of view. Thank you.
Okay. Either Philippe or Mr. Suyamori, you have any contributions on the question of any observations for managing technology leakages or ITT best practices? I know that, Philippe, you mentioned you're not an export control geek yet, but from an economic perspective, I suppose you've already mentioned investment screenings. So maybe we can unpack that later, and you may well be able to give them an idea of how is it that companies can shield themselves in protecting their digital assets or their IP, perhaps. And maybe, Mr. Suyamori, you can focus on technology leakages.
Technology leakages, ITT, is very hard to deal with.
Yes, especially with fiber optics. And in the morning, Mr. Lim mentioned
Right.
with quantum fusion and quantum technology, we have read in the papers with technology transfers from fiber optic cables. So yes, it's very hard.
But Japan has a scheme to control foundational cutting-edge technology, control those technologies under the law. We have the dialogue scheme between government and private sectors. METI require prior notification to exporters with specific foundational technologies that have concerns about future military use. So the two sectors, private and public sectors, will have a dialogue on appropriate technology transfer control measures to prevent unintentional technology leakage. We specified 15 areas that should be covered for the dialogue.
Can I maybe take from the morning? In the morning, Mr. Rizwan had mentioned that in Malaysia, MITI, if you are dealing with the transfer of technology or these chips in Malaysia, the AI form would be filled up on a voluntary basis, notwithstanding that it's not connected to a relevant activity. So in METI, if the export of the technology is not connected to a relevant activity, is that process still applicable?
It's case by cases, but it might be used for the in the future. That might be related to future military use. That is the area the exporter should have consultation with METI.
Right. So I think it's important to leverage on the public-private partnership and to approach METI when in doubt, so that you can build up that reservoir of goodwill. Perhaps let's now transition to Philippe. I know that nobody in the audience has asked, but maybe we should think about this since you mentioned investment screening. In the press, we've heard about Nexperia. is not the EU's doing, of course. This is the Goods Availability Act in the Netherlands. But it speaks to what you mentioned in the morning with investment screenings and how businesses may find themselves having to pick the right partners and be a bit more sensitive to evolving threats. From an economic perspective, what advice would you give our businesses in Southeast Asia when it comes to, I suppose, finding the right partners, establishing themselves from a governance perspective?
Again, I think I cannot give any advice in that sense. I can only observe how it works in the European Union. I mean, the first thing, intangible assets, if it's an export, I don't know how we operate, but it's very difficult. That's clear. Now, the other thing is that's trade. The other one is investment. Now, and then there's a question of tech leakage on inward investment and on outward investment. So we have a legislation in place on inward investment in the sense that investments from non-EU countries are screened in, let's say, with the perspective whether there is a concern for our security and our public order. And under this regulation, for example, investments in electricity grids have been prohibited, just as an example, which is. This came actually from negative experiences we made on technology leakage in Europe by foreign investments and leakage of, let's say, advanced technology, which is strategically sensitive, for example, robotics. Yeah, so that's where this came from, and this investment screening, inward investment screening regulation is also still relatively new and is a lesson learned. Now we are now looking at, I mentioned it in my presentation, we are now looking at outward investments again, because outward investments in high technology could lead to leakage, be it solely by forced technology transfer at the, in the host country of the investment. And we are now evaluating the risks. So there is a risk evaluation ongoing where member states are looking at outward investments in quantum semiconductors and the third technology, I don't remember, where to see in retrospect whether this has created a risk. On that basis, we will probably establish recommendations on the course of action, which again then could lead to a kind of screening in the end. Yeah, we're not there yet. I think the member states had to report back on that assessment in June, but this now has to be processed, and I think mid-next year there might be some recommendations on the course of action on that.
So I think what you are speaking to and what Sumori-san and So-young had mentioned is that screening undercuts several different areas because it may go back from a post-transaction perspective to how the EU is examining it. In Singapore, I'm sure many of you here are familiar with the Significant Investment Review Act, which has identified sectors where the government will obviously consider where the nature of investments are coming from. But that all being said, screening is not just your day-to-day screening or product classification, there's more to it, and that speaks to how you may have to enable your businesses to be a strategist. With that said, I am looking at the organizers behind. How much time do we have? Do we still have enough time for 2 more questions? We have time for 2 more questions. Now, the next question, you'll be happy to know, is a very easy one, and Philip, you may not have to answer this. To Ms. Kim and to Mr. Sumori, the audience have indicated by asking, are there plans to provide English versions of the regulations and control list for Japan and Korea because they find it challenging in order to be able to check for applicability and requirement? I don't, I speak both fluently. I'm kidding. Are there plans to provide English versions of the regulations and lists in English? This is the easy one. Yes, no. The answer is no. use generative AI to translate for you. This is the leveraging technology part.
The answer is no. Of course, you can find a list based on the Japanese version, and you can find easily by making use of artificial intelligence. That is, of course, related to four regimes. That might be slightly different from four regime or EU or US version, but basically the four regimes.
I think it's fair. To be honest, I mean, just FYI, the term catch-all controls, in Arabic, catch-all controls is so different in interpretation from what it means in English. So I'm thinking that, you know, getting them into English places the regulator and a bit of a challenge to understand what you believe to be native, when now you have ChatGPT, I think. But of course, Miss Kim and then Philippe.
I don't like to echo Mori's answers again, but
Is that a yes or a no?
no. Our agency have that kind of documentations already, but it's not open to the public. But afterward, we hope to open to the public after negotiating with government ministry again, and then you can and for that time, and you can use it on that time on.
So look forward in the future, in the 14th edition of JIO, we may see whether there might be an update. Philip, you wanted to add in something here.
I just wanted to say we have 20 languages, so you can pick and choose. But that's of course because we have so many official languages in the European Union, so we are obliged to do this by law. But I can tell you, just as a warning, we employ thousands of translators so it's a very, very cumbersome and expensive process as well.
Okay. I'm scanning the room. You know, by now we are all warmed up to one another. There's less inhibitions. Anybody wants to ask a question that has not yet been asked before we find one? Everyone is still comfortable? Everyone's now looking into your CV. You have one last chance to vote. I'm scanning to see which would be a final question that we can ask here. There are a lot of questions that are IP related. You've got to forgive us. We're not going to take data protection related questions here, given that the theme is export controls. But this is an interesting question, particularly in the advent and the direction of which we are traveling. What do companies need to verify when many things are on cloud servers? What do companies need to verify when many things are on cloud servers? I'm going to give the panelists a few minutes to think about this. But it sounds to me that the question you're asking is, you may be using an Amazon cloud, you may be using a Microsoft cloud, you may be providing services to others using trained algorithms, and that your data may be stored in the cloud. You may be selling these items to others who may be buying this, and you may not know who they're on-selling it to. And ultimately, you may not meet these people. So it sounds to me like it's a little bit more sophisticated than a technology control plan that you may or may not have. But at the same time, how is it that you're going to manage the cloud? I think this is ultimately a question that you may have to discuss internally in your organization, but let's see how our panelists would look at this. How do you recommend that our audience here consider managing the cloud? Anybody who feels ready to, is our final question. This feels like a Jeopardy show now.
This is an unofficial comment. If you feel that your activity is a little bit suspicious, that is true.
Yes.
I mean, this is a sensitive area, and then, of course, by law, it stipulates that the goods transfer can be regulated, but in terms of technology or service provider, this is the area of discussion, I think.
Yeah.
So if you think that might be sensitive, that must be sensitive.
I think that's a fantastic point. In fact, the circular left on the table behind by Singapore Customs is also a very helpful reminder how what may conventionally apply may continue to still apply even in the intangible domain. Either of you, what are your thoughts?
Basically, we can think over the basic control ground. Just when it comes to deemed expert, just regardless within domestic or outside domestic, we need to control it. And then regardless of national, regardless, no, I mean, back to my point, just regardless within domestic and outside domestic, we need to control the technology. So you need to cautious about the strategic system again and again, and the cloud. Even though the cloud, you just want to store your information or technology by yourself, but the objective targeting is also would be related to the foreigner or his other counterpart as well. So likewise, Mr. Suemori mentioned about that. Must be must be keen about this point again and again. Thank you.
So due diligence still applies to the cloud. Philip, last but not least.
First, of course, there's the wisdom of Mr. Sumori, I think one can all share this. But maybe I'm too simplistic, but it comes back to the same question as we had earlier as well about, third-party service providers. So the cloud is a third-party service as well. So again, there's, I think, the obligation to exercise due diligence, one thing. And then the other thing is that then you can enter into the very tricky discussion on data localization and data localization requirements. And some countries are actually imposing data localization requirements for strategically sensitive data, as they do for personal data. I'm not promoting this, I'm just saying this is what is happening, but yeah, it's one, let's say from, maybe my first reaction to that.
No, I think so. I think ultimately you know your clients and the industry the best. And if you notice something odd is likely to be, you just don't want to find out months later where you either are involved in an investigation or where regulators are sharing information and they find out that you were in between that process. So I think the same approach that you use for tangible controls are the underpinnings for how you would approach the intangible. And that's something that I remember from a BAFA presentation that I attended many years ago, where if it's the same principles, you could continue to be thinking about everything that we've spoken about today. With that said, I wanted you to show my appreciation for a panel, for a deep round of insights. Can we give them a round of applause? Soyoung, Philippe, Suemori-san, thank you. Please, let's return to the rest of the program. Thank you. Thank you.
Thank you very much.
Thank you. On CVent, the feedback that you provide will help the organizers, help you curate next year's program. So any feedback that you do means that the 14th JIO would be successful owing to what you do today. I'll encourage you to take your phones or your computers and follow the instructions. I'm told that it's intuitive. You open it, you'll see, take survey, click, answer the questions, and you're done. I'm going to give you a minute or two to do this. For those of you who may be having any difficulty accessing the survey, please put your hands up and then we will get someone to come and help you. I hope you've managed to get the survey done. Now, every time we attend the GIO like you and I, we never get to appreciate the significant number of people that are responsible to make today possible. On behalf of all of you, I wish to thank the organizers, the crew from the Shangri-La, the AV crew, the many people who came so early in the morning, as early as 5-something in the morning to set up, be here, to provide you your lanyards, to provide you a seamless experience. Let's express our appreciation for them by giving them a round of applause. I think ultimately, as we close for the day, and if you are still doing your surveys, can I see a show of hands? How many of you are still doing your surveys? Very nice, very diligent, please. Carry on with the completion. Ultimately, export controls is a shared responsibility. We've heard the word control so often, but ultimately I think what we're really trying to do is to lay resilient foundations for a secure future. And I think all of us, with our collective efforts, which I mentioned from the beginning, solid interagency, the use of innovative mechanisms, and our interconnectedness is what is going to continue to inspire us into doing well and doing good, and to making sure that we don't put profits before principles. And I'm wishing all of you a very successful rest of the day as you continue to interact with the others. And once again, on behalf of the organizers, I want to thank you. And if you have any questions, feel free to approach the organizers or myself. And we look forward to welcoming you to the 14th JIO next year. Once again, thank you.